Hi guys. So today we're going to talk again about DNA because the DNA is the only evidence in this case. And the amount of people who make statements like, oh, DNA doesn't lie, and then they completely close their minds to any alternative explanations is terrifying. DNA is not foolproof. There's so much scientific research to show that. And this isn't something that defense attorneys make up just to try and win a case. DNA evidence shouldn't be used on its own. But why not? Because things can go wrong. Evidence can be contaminated, mislabeled, packaged incorrectly, stored incorrectly. DNA testing can be interpreted or reported incorrectly. The wrong data sets or comparisons might be used to come up with likelihood ratios, so it might be misleading. And the DNA might have been there before the crime, or it might have been unrelated to the crime, or there may be some other explanation as to how the DNA got there. So without more information or a clearer picture with more than just DNA evidence, you can't reliably make a conclusion about something. So science is my jam. I have a science degree and my professional background is in allied health. So I've been deep diving into the scientific research. I've been reading lots of articles and thinking a lot about the Tara Baker case, and I'm going to talk a little bit about my thoughts and my concerns related to the evidence in this case that we saw in the trial. So obviously I don't have the answers. I don't have access to the evidence. I don't have access to the reports and things like that. So I can't say anything for certain, but hopefully this does give you some food for thought and definitely some reasonable doubt. So we'll talk about contamination first. So this article here is just talking about contamination during criminal investigation. And this is where secondary DNA transfer can happen from evidence bags. And it just talks about that in forensic labs, often they do try really hard to follow best practices and to limit contamination. But sometimes police don't always follow the same standards. So this research looked at different case work in a certain time frame, and it showed that the DNA from police staff could actually be transferred from the packaging or the outside of an exhibit to an exhibit, which basically contaminates it because it's putting a DNA profile on the evidence that isn't supposed to be there. So that's that example. I found this website. It's an Australian website, Roebuck Forensics, and there's a lot of really good information on here about challenging DNA evidence and the problems that can happen with DNA evidence. So, unless challenged, DNA evidence will generally be heard by the court. The underlying science must be properly examined to determine reliability. Contamination can falsely implicate a person at the crime scene. Contamination is far from uncommon and is one such basis for challenge. DNA contamination can render evidence unreliable and lead to its exclusion. So this is actually an example of a case in Western Australia where the DNA was excluded and then they obviously couldn't prosecute because that's all they had. So, it says DNA presence can seem conclusive, but DNA evidence can be wrong. So it was alleged that firearms within a locked shed belonged to the defendant. The DNA testing by the state lab identified a DNA profile matching the defendant, and the DNA results upon firearms were substantially relied upon to support the prosecution. So it was a locked storage shed with lots of general items, and the police conducted a search with over 10 officers. Firearms were located along with other items, including ammunition. The items of interest were bagged and removed for later sampling and DNA testing. Over 40 minutes of video footage was recorded by police throughout the search, and the footage depicted police variously handling items during the search. The shed was understood to be accessed by the defendant and another individual and contained goods belonging to both persons. So it just says here that whilst we're talking about firearms, these contamination issues can happen in other instances as well. So the DNA report identified that the DNA matched the accused, but the DNA report doesn't review or report the sampling or crime scene handling. So in this case, there'd been issues raised by the defence to the prosecution about the crime scene handling, and the lab expert had reviewed and reported upon the search footage, and they saw lots of issues with the police handling of items. So yeah, they couldn't rule out that contamination was what put the DNA on the item in question. So there was a hearing, the admissibility was challenged, and the DNA evidence was not let in. If you want to read that, you can. So this next example is another Australian case from New South Wales where DNA evidence was excluded before the trial. And it says the courts have the power to exclude DNA evidence where it risks being misunderstood or overstated. So this is the allegation. So you can read through that if you like. So there was the DNA, but the presence alone doesn't determine whether the evidence is admissible. So the report could not conclusively link the DNA to a specific body fluid. Does that sound familiar? So DNA transfer can occur during non-S social contact, and this one talks about because it couldn't be conclusively linked to a specific body fluid, then it would be touch DNA. And this is, I mean, to me, this seems obvious, but I didn't see this really taken into account in Edrick's trial. So in criminal trials, DNA evidence is a form of forensic scientific evidence, and like any forensic evidence, it may be challenged or excluded where its probative value is outweighed by the risk of unfair prejudice. So the judge said that the DNA, because the DNA profile cannot be attributed to a specific biological material, it is a trace DNA. And trace DNA can be transferred directly and indirectly, and it's not possible to determine whether the DNA was deposited through direct contact or whether it was secondary contact. And because the amount of DNA was such a low amount, that just goes to the fact that it was trace DNA. And that is not strong enough for court. So there you go. There's that. And there's surprisingly quite a few articles about DNA transfer related to rugs and things such as these. And I thought that's quite relevant because when you look at the context of when this case, originally happened, college town, young students partying, involved in drinking, recreational things, and it's not a stretch to think that there could be these kinds of factors involved, especially when you look at Edrick's previous convictions or, charges related to possession and things. So it makes sense. So yeah, DNA does transfer from surface to person and then person to surface and all of that. And it can transfer on the packaging that a rug might be in. This one here talks about capsules. So this is MDMA, I think, where they're looking at mimicking the loading of capsules, and obviously people will be handling it, and that actually there was DNA transfer that way as well. So there is actually quite a lot of literature on secondary DNA transfer and its implications in forensics. There's too much to go through. In Edrick's case, I think part of the problem is the fact that it was a cold case. So it's okay to look at possibilities of how DNA could get somewhere. But when you're looking at something that happened 20 plus years ago, how fair and just is it to implicate somebody and then tell them that they need to provide evidence to be able to present an alibi? It's pretty ridiculous. And then if Edrick had wanted to say, oh yeah, I did see her out and about and had an encounter with her or whatever, he wasn't allowed to say that because number one, he didn't have any evidence, and number two, the rape shield law would have stopped him from being able to make any suggestions of that without any evidence. But come on, guys, how are you going to have evidence 20 years later? You're not going to remember everybody you hooked up with either, are you? Especially in your college days. So yeah, it's just another thing that is very problematic in this case. So Edrick was involved in a crime that happened not long after the Tara Baker incident, and that would have involved his DNA and evidence and things like that going through the lab at around the same time as the Tara Baker case evidence and things would have been going through. So the accidental transfer of DNA is plausible, especially when you look at factors like the mislabeling of the evidence and the problems that they had with the chain of custody with the DNA evidence as well, and just the age and just the unknowns about what the procedures and things were at that time, or knowing, how much those things were adhered to. So we could give the state the benefit of the doubt, Maybe Edrick's DNA really was there the whole time, and maybe it got there for reasons unrelated to the crime itself. But if you've seen any of my other videos, it seems unlikely to me that they wouldn't have found his DNA over the past couple of decades. So that leads me to the corruption angle, which isn't my usual go-to, but in my opinion, when you look at the whole picture here, it's not out of the realm of possibility. I actually think it is a reasonable explanation. The Coleman-Baker Act, the pressure to solve the case, and the magical appearance of new evidence, that in itself is enough to raise eyebrows. But then you look at the speed at which they pounced on Edrick and arrested him with absolutely zero other evidence, disregarding red flags like Chris Melton, for example, and another unidentified DNA profile. And then, conveniently, due to the passage of time, Edrick's ability to defend himself was already pretty low. And then you add in things like the rape shield law, some racism, and some politicians in the courtroom. Well, I guess I'll leave you guys to make up your own minds. See ya.